Okay, we're just about to get started here for the final session in the zoning board track today, which is the ZBA Q&A session. So we have Steven Whitley and Cordell Johnston here today. We've some old pros here at dealing with questions at this conference. And I want, before we get going, I've been looking through the chats, through this particular chat for the session, for the track. A lot of questions have already been answered, either during Cordell's session. He answered just about all the questions that came in. There was one last question which came in about half an hour ago about variances. I encourage you all to look in the chat for that right now. There is a reply from Cordell to that. There's one other question which I'm going to get back to because there were also several questions which we did not have time to get answered during session 2. So if it's okay with you all, I will ask them and either one of you can chime in with an answer. So let me just start with those questions. Meanwhile, while we're going through some questions and you, the listeners and watchers, are here and listening, feel free to put some more questions in the chat. We will get to as many of them as we can in the next hour and 15 minutes. So going ahead from session 2, first one, if a variance timeline has expired without being acted on, due only to an abutter appeal, has the timeline really expired, or does the timeline start after all appeal periods have passed? So I hope that's not too out of context.
No.
Okay.
First of all, can everyone hear me and see me? Because this is my first session here.
Yes, I can hear and see you.
Ken and Cordell acknowledging. I can't see anybody else. That is a really good question. That's one that is not clearly answered by the statute. It is currently, I know of at least 2 appeals in Superior Court trying to address that very question. Unfortunately, there are no decisions issued on this yet, at least that I'm aware of. Maybe Cordell is aware of some Superior Court decisions on this. There's no Supreme Court guidance on this. That expiration language is fairly new, and so it hasn't been scrutinized by the Supreme Court as of yet. My personal view is that if there's an appeal that's been filed by an abutter, that should pause the 2-year period. But again, that hasn't been resolved by any court decision that I'm aware of as of yet.
Yeah, I would agree that, I mean, that if that would be patently unfair, I think, to the person who got the variance. Someone appeals and as you know, people can drag out appeals, and in the meantime 2 years expires. I would think that it ought to remain valid until the resolution of the appeal. And I would just note that the statute doesn't address that, but it does say that variance shall not expire, or no variance shall expire within 6 months after the resolution of a planning application. So I get a variance to build a restaurant, and then I have to go to the planning board for site plan review, and that takes 3 years for some reason. The statute basically says that as long as I'm in site plan review and for 6 months after that, the variance remains good. So I think the intent is to allow a variance to remain valid for as long as the appeal process plays out.
I can add to that the argument I heard from the other side, which I don't agree with, but the argument is the statute allows you to request additional time for good cause. And so the argument is that if an abutter appeals, that is your good cause to request an extension. Again, I don't agree with that. I think Cordell and I are on the same page with this. We're just waiting on some court guidance to hopefully back us up.
Yep.
Okay. Great, thank you. I just realized I should move forward one slide here, just so you see who's talking. So Stephen Whitley from DrummondWoodsum and Cordell Johnston back again as well. So continuing with some of the questions that came in the chat during the second session. Next one, is the town responsible to notify the landowner when a special exception or variance has expired? How do other towns track expired special exceptions and variances?
I haven't had to deal with it. My gut reaction would be no, there's no affirmative obligation to notify. It might, maybe a polite thing to do, but then then you have to keep track of it. Steven, have you dealt with that issue?
I have, but it was for a situation where the two property owners had a sort of a long-standing dispute, and the town had also had a long-standing dispute, and so we did provide notice that the expiration deadline was coming up, and that's because we expected to be in court, and so we wanted to have something to point to say, the owner applicant was aware that the expiration period was about to be up. And that's why we did it in that case. But I agree with you that there is no affirmative obligation to provide that notice.
Okay, thank you. And then following up, that was about 20 minutes later during that session. Does the legal definition of substantially complete apply to equitable waivers, or is it simply 50% or more complete?
I don't believe that that definition is included within the equitable waiver statute, and so I don't think you can assume that it would apply.
I'm going to defer to Steven on that one, unless I can find a quick answer.
Sorry, Cordell, but I thought that Jason may have mentioned this in some of his materials. I don't think it's the same. I think it's the 50%. I mean, if we're talking shorthand definitions, I think that's the one that is likely operable.
Okay. Okay. So now I move forward to the questions that were coming in just before we started. I see we have several more that have come in as well. So this is a question about how the ZBA might apply RSA 676:14, which is the determination of which local ordinance takes precedence. How does the board determine which provision of the local land use ordinance imposes the greater restriction or higher standard? Is there any case law or examples you may have? And then they add, for context, some ordinances in my town may address different land use controls, but when interpreted together, they could or do conflict.
There's no case law interpreting this that I'm aware of. And I think that it really depends on, it's not a very satisfactory answer, but it really depends on the ordinance language in question and the facts and circumstances of each case. And I think the way I think of it is the ordinance that is more limiting and restrictive for what someone can do is the one that ought to control. And so the less.
Yeah, and in most cases, I think it'll be pretty easy. For example, your ordinance says that the maximum building height is 30 feet. And then in a separate section, there's something that says any property abutting a school, the maximum building height shall be 20 feet. Well, obviously, if you're abutting a school, that takes priority over the 30-foot limit. And as I say, that's an easy case, and I think most of them will be easy. But there are some where you have one thing that's more restrictive here and another thing that's more restrictive there, and you have to kind of put them together. And I would agree that that's a facts and circumstances thing that we probably can't answer with hypotheticals here. That's as I frequently said this morning, and again, not trying to gin up revenue, but that's probably a question for your local legal counsel.
Okay. All right. So now we're getting into some comments that started that have come in since we started the session. Roger says, when does the clock start for the 45 and 90-day deadline? How should the ZBA handle grossly incomplete applications, such as the form not fully filled out, lack of an abutters list, no fee?
And,
So
and Ken, I had actually started to answer that
okay.
one already.
Is that farther down? Okay. Oh,
yeah,
time frame. Yep, got it.
As far as I got on the current chat.
Yep.
But so you said it starts on receipt of the application.
Right.
So he goes on, how do you handle a grossly incomplete application? I think when I was talking about it this morning, I said, if you don't get enough information that you can make a decision within 90 days, then you can just deny the application without prejudice, saying we don't have enough information, and they can file a new application when they're ready to do a better job.
Mm-hmm.
I would also back up and say, keep in mind that there is an obligation to help the applicant to some extent, to help them with the process. And if they don't know how to file an application, someone ought to be at least telling them what needs to go in the application. But if even with that help they can't get the information that you need, then it's either get them to waive the time period, or say you're going to deny it until they provide more information and they can come back.
Okay. Let's see. Do you have an opinion on tape recorded transcripts of ZBA minutes versus a general summary of ZBA meeting discussions? So recorded / transcripts or general summary?
I would say that the law does not require transcripts and tape recordings. And so as long as you can meet the legal requirements in 90A, 91A 2, a summary is legally permissible. I think if you end up in court or before the HAB, the more detailed the minutes are, it can be very, very helpful for that appeal. And sometimes that doesn't help the municipality that I'm defending, but it is easier for the judge or the HAB to understand what happened below. But transcripts are not a legal requirement for meeting minutes.
Steven, if a ZBA does have a transcript or does have a recording,
mm-hmm.
would you and the decision gets appealed and you're representing the ZBA, would you include the transcript and or the recording in the certified record?
Yeah, that's a good question. So the current practice in the land use court is that the recording itself is not enough. The court wants an actual transcript prepared by, a certified or a licensed transcriber. And so if you already have that, then yeah, that would be part of the record, that the certified record that goes to the court. And if you only have a recording, then the parties usually try to work together to pay for the cost of transcribing the tape recording so that it can be added to the record.
Okay.
Okay. This is sort of a general question. So commenter is saying ZBA at one point when any ZBA cases were going to the Housing Appeals Board, the results were faster than in the courts. They believe that for this fiscal year, the HAB funding was cut a lot. Is it still functioning? Is it as timely as the past?
It is still functioning. It is now only 2 members, and I believe it's been moved to the Board of Tax and Land Appeals, but it is still functioning. I haven't had anything there since that change in law, and so I don't personally know about how timely they are. My experience prior to them being moved was that they were actually pretty slow. They went through some membership issues, and so there was a backlog for a while. I think they may have worked through that, and so they may be pretty close to the statutory schedule they have to comply with. But again, I haven't had anything there in a while, but they do still exist.
Yeah, I haven't had anything there either. When it was first set up, I had a bunch of cases that went to Housing Appeals Board. I think what has happened is shortly after that was formed, the legislature created the land use docket and appointed judge or Judge Class was appointed to hear land use appeals in the Superior Court. And the lawyers who represent applicants or abutters, anyone appealing a ZBA decision, would rather go to Superior Court than to the Housing Appeals Board. So all the appeals I've had in the last 2 years have been in Superior Court. It's never been my choice. I'm always defending them.
Okay. Thanks. Change of topic here. If a town does not have a Class 6 road policy and the zoning ordinances require 200 feet of Class 5 or better road frontage, does the new legislation void the ordinance, i.e. no variance required to obtain a building permit on a Class 6 required, only a waiver of town responsibility?
My view is no, that it does not, the new legislation does not void the zoning ordinance. And this is a really tricky area of law. And the way that I tell my clients to think about it is that you have 2 layers when it comes to building permits on Class 6 roads. You have the local zoning frontage layer, and then you have the 674-41 state law layer. And the state law does not eliminate or trump any frontage requirement for a Class 5 or better road. And so even though the state law may have changed and may have made it easier to get a building permit on a Class 6 road under state law, the owner may still need to go to the ZBA to get a variance if the zoning ordinance requires frontage on a Class 5 road.
Yeah, when that statute was amended last year, people kind of freaked out. And I mean, I agree that I didn't like the amendment, but people were saying, oh, we now have to allow building on Class 6 roads. What are we going to do? And I read that everywhere. And I believe there were attorneys saying you have to allow building on Class 6 road, and that is absolutely not true. The amendment loosened state requirement. But the local ordinance still can be as strict as you want it to be. I mean, the local ordinance can still prohibit building on Class 6 roads.
Mhm.
So people should not be panicking about that. It's good to look at your ordinance. And I guess the one thing I would say is if you were relying on 674-41 alone to inhibit building on Class 6 roads, and you didn't have anything in your ordinance, then you might want to put something in your ordinance. But if you already have something that requires Class 5 road frontage, you should be okay.
Okay. Let's see, what's next? Okay, this is says regarding fees which a land use board collects from applicants. Looking at RSA 673:16 IIC. Anyway, it states in part that such fees shall be held in a separate non-lapsing account and not commingled with other municipal funds. So what is the practical application of this RSA? Seems unlikely that this requires towns to open a separate bank account to handle collection and distribution of such fees.
I've never dealt with that before. I don't know about you, Cordell.
No, and I think I guess I'd see that more as a town finance question than a ZBA question. But I think it's probably true you don't have a separate. I'm not sure. It may be true that you don't have a separate bank account, but that there is some way within a bank account to segregate funds. Not my area of expertise. But I mean, it does clearly require that they be separate and not commingled. And I mean, obviously you want to make sure that those funds don't lapse. But as to the details of that, I'm honestly not sure.
Yeah.
Okay. Yeah, it sounds like a question for the people who handle the accounts in your town. Okay. Now a question. Can someone clarify the hardship criteria in simple terms that we can use to explain to an applicant?
You want to go, Cordell?
The question is about the hardship criterion. Okay,
Yes.
I'll do my best. The first thing I would say is ignore the word hardship, because the statutory term hardship does not mean hardship the way any normal person thinks of it. You hear hardship, you think, oh, he needs to do this because he needs the money. It has little, if anything, to do with financial hardship. What the statute says basically is, one, there are special conditions of the property that distinguish it from others in the area. So first you have to establish that there's something about your property that's different from others in the area. Size, shape, slopes, wetlands, whatever, that makes it significantly different from others. And then you have to show that in light of those differences, there's no significant relationship between the public purpose of the ordinance and the application of that ordinance to the property, and the proposed use is reasonable. I'm reading this from a memo that I wrote. I'm gonna paste it into the chat right now. And I would suggest going back to the example that I posted earlier, where I said, an example, you have a property located in a residential district, only residential dwellings are allowed, but it's right across the street from a commercial industrial district. So all the properties across the road are industrial, and your property in the residential district is surrounded by pre-existing uses that are also commercial or industrial. So you're sitting there as a lonely residential property surrounded by commercial properties. In that case, I would say that your property is significantly different from other residential properties because it's basically in the middle of a commercial area. So that's the special conditions. And in light of those special conditions, it doesn't make sense to apply the restriction in the ordinance to your property. And your proposed use of the property, you want to build a convenience store, and you're surrounded by gas stations and car washes. That is reasonable in light of the unusual conditions of your property. That's just one example, but it's the best example I can think of. And I don't know whether that helps. It's very, very hard. But always start with the special conditions part of it. If they can't show that there's something unusual about their property, then you can end the question right there.
Okay, yeah, that's always a good way to think about it. Okay, so in this commenter's town, their ZBA acts as the Building Code Board of Appeals. RSA 675:5 doesn't technically apply to the time for that kind of appeal. Is there a statute specifying the time for building code appeals? Should we assume 30 days?
I was looking as Cordell was answering, and I've not been able to find a statutory time period to bring a local appeal of the building code to the Building Code Board of Appeals. I don't know if Cordell, if you can put your finger on one, but I would just say in the absence of any express time frame, you're dealing with the sort of common law. It needs to be brought within a quote reasonable time, which is very dependent on the facts and circumstances.
I think that's right. But I also, and this is answering a different question. I don't know whether people are aware of this legislation that was enacted last year, and it was never codified. So it's sitting out there as an enacted law, but it is not in the RSAs anywhere. And it says that appeals of decisions regarding the state building code must go to the state building code review board. They no longer go to the ZBA. I'm going to see whether I can find that new law. This is an example of just gross legislative incompetence, that they passed a law and never codified it anywhere.
Cordell, I'm looking at 155A Roman 11-B, which goes into effect July 1. And it says something similar to what you're saying, that the board shall hear and decide appeals made by the local building official relative to the application interpretation of the state building code.
Okay, maybe they finally decided to codify it this year.
Yeah, they may have put it in finally.
It's 155A what?
11-B.
Okay,
And it replaces the current version of 11-B with a new sort of iteration of it. It's actually a little confusing because it also goes on to say that the board, the state board, also hears appeals of final decisions of the local building code board of appeals.
right.
Yeah.
If you have if you have a if you have a review of a building, if you have an appeal of a building code decision that's going to the ZBA, once again, I'm going to say, talk to your legal counsel about whether they should even hear it or deny it, because it's supposed to go to the state building code review board.
Okay, I think I found the answer. Sorry for the extended dialogue, but there's a new version of 674-34, which goes into effect July 1, which limits the jurisdiction of the building code board of appeals to local amendments to the state building code or state fire code. So
Yep.
that's the only thing the local building code board of appeals is authorized to hear. Everything else goes to the state building code board of appeals.
Yep.
But circling back to the question of timing, I still don't see anything addressing that timing question. So I think it is, the quote unquote reasonable time standard.
And what was the statute you just cited?
674-34.
Okay. And while you were reading that, I was finding the bill from last year, and it was Senate Bill 188 from the 2025 legislative session. It was passed. It was signed by the governor, but it doesn't appear in the RSAs anywhere. And maybe 674-34 now it achieves the same thing. I'm not sure.
Yeah.
But so anyway, yeah, sorry for the mess. But it's not our fault.
I was going to say, I'm not going to apologize because we didn't do anything.
Right.
Okay, I have another question here, which actually comes with its own one-word response. But the question is, would a board be setting a precedent if we inform a citizen that their application is going to expire?
I don't think so.
Okay.
Yeah, I'm not sure it's a precedent, but it does demonstrate the usefulness of trying to be consistent, and therefore maybe not doing things that you don't have to do, because if you do them this time, someone's going to say, well, you did it for him, why don't you do it for me?
Yeah, and I think if that happened, the town would need to be able to distinguish those two situations to try to explain the different treatment. And I think back to the issue that I was involved with, where we knew we were going to end up in court. There was a long-standing dispute between the town and these property owners, and so we did give that notice. But it was because we were anticipating an argument about expiration, and so we wanted to be able to show the court that we had informed all the other parties of the town's position.
Okay. We have a follow-up to the hardship criteria issue. So the question is, does special conditions of the property that distinguish it from other properties in the area, does that mean the property has to have some singularly unique property that differentiates it from all other properties in the area, or just different from, for example, many of the properties in the area? An example might be a property that is smaller or larger than called for by the zoning ordinance, but it is not the lone property like that.
That's a good question. I think it's the latter. I don't think that the law was intended to only apply to, unicorns with wings. I think it is instead intended to capture the maybe more numerous but less frequent property characteristics in the area.
Yeah, I agree, and I think I have some authority for that because it was cited against me in a case. Just to be clear, I still won the case, but someone who had applied for a variance and had it denied cited the case of Community Residents for Justice versus City of Manchester. It's a 2007 case. It says that the property need not be the only such property. So as Steven said, you don't have to show that it's a unicorn with wings. Doesn't have to be completely unique, but it could be one of a few that are very different from other properties in the area.
Okay. Here's a terminology question. Can you explain how a variance application is an appeal? So the term appeal.
Yeah, the statute that creates the jurisdiction for the ZBA to hear, what it can refers to appeals. And so that's one reason why, is because that's the way the statute talks about what the ZBA can deal with. And I think maybe the more sort of pragmatic answer is when you're seeking a variance, you're asking for relief from some term within the zoning ordinance. And so you're maybe the common understanding is you're appealing to the ZBA to give you relief.
Yeah, and I've actually heard some people say that before, and I don't agree with this, but before you can request a variance, you have to apply for a building permit and be denied.
Yeah, no, I don't.
You don't agree either. Yeah.
No, I don't. I'm yeah.
And there are some, I believe there are some towns that require you to do that. So if you have a 1 acre lot that you want to build on and the minimum lot size is 2 acres, they'll say, okay, apply for a building permit. We'll deny it because you have a non-conforming lot, and then you can appeal to the ZBA for a variance. I think that's a waste of time.
Yeah.
But that, in that sense, it would be deemed an appeal. So just to be clear, in that case, I would say just apply for the variance. Don't waste your time, or don't make them waste their time applying for a building permit and being denied.
Yeah.
Okay. We have run out of questions that have been entered into the chat. So of all the people, sorry, go ahead.
I have a question. It was raised earlier in my session. It said, I want to see what Steven thinks about this, or maybe we can talk about it. The question was, if a ZBA's decision is appealed to the Superior Court or to the Housing Appeals Board, do they have to defend it? Can they just say, we don't care?
No, I don't think you have to defend it, but practically, I don't know how you do that.
Yeah, I'm not sure either. And I was wondering whether you've ever had a case. I had one recently where ZBA granted a special exception. The abutter appealed. I wasn't involved until the appeal, and then the planning director called me and said, we have this appeal. ZBA doesn't really care about it. It's not a big deal, but they made their decision. do we have to defend it, or should we just let it go? And I said, well, I think, we ought to at least mount a token defense, at least appear and file something. In the meantime, the planning director called the applicant whose special exception had been granted and said, your neighbor appealed this. And the applicant said, okay, we're not gonna we're not gonna get involved. if the court reverses it, we'll just move somewhere else. And it was a barn that they wanted to build. We'll move somewhere else and build the barn there. So just to finish it, I said, well, we'll put in an appearance and go to the hearing. And that's basically what I did. I filed an answer. I went to the hearing. I argued for why the special exception should be upheld, and they Judge Class upheld the ZBA's decision, even though I hadn't put that much effort into it. But what if the town had just said, because it's a ZBA's decision, but it's the selectmen who are deciding whether they're going to pay the lawyer.
Right.
And the selectmen say, we don't care about this. We don't want to pay to defend this case. What happens then? And I've worried about that situation, but never had to deal with it.
Well, and what I was thinking of is, if the town takes a very hard line position and doesn't want to spend or put up any fight, that means that no record arguably gets transmitted to the court.
Right.
No appearance, no answer is filed. If any or all of those things happen, the town is likely in default. And I think that the court could rule against the town because of the failure to do any or all of those things. I think I would be careful about dealing with it that way, because I would be worried that an abutter may ask for their attorney's fees if they have an attorney involved. And I've never had it happen to me personally, so I don't know precisely how it would play out, but those are, I guess, considerations to think of.
Yeah, it always seems to work out. And there is a provision in, I think it's 673-14 or 16, that says that the land use boards can accept gifts. So if somebody wants to donate the money to pay the lawyer,
yeah,
they can do that.
Yeah.
Or if, I don't know whether there are any towns that do this, if the ZBA actually has its own legal budget.
Mm-hmm.
I think that's probably pretty unusual. But the practical thing is, it's the governing body that's deciding whether they want to pay a lawyer to do this. And I guess my thought is just try to work it out.
Mm-hmm.
Okay. Do have another question, and it says variance decisions should be complete and cohesive and well written, as they may be challenged in court. Would it be proper to prepare both an approval and a denial decision in advance of a meeting? And he means they would draft the decisions and then amend them during the meeting based on the info.
I mean, I think it's fine to do that. I think the tricky part is, are those drafts being circulated to the other board members ahead of the meeting? And that's where you can get into a little bit of trouble. And so, yes, it's fine to draft them. I think best practice is that the drafts not be shared with anyone else on the board, and that the member that drafts them, comes to the meeting and says, I've drafted these two decisions, depending on how the public hearing and the deliberations work out. I will fill them in as we go along, and then I can provide them to the other members or read them to the other members to review while we're deliberating.
Yeah, I would agree. And I have seen one of the towns that I represent their former planning director would actually draft motions himself before the meeting, one motion to grant and one motion to deny, and fill in, just very kind of generic reasons for the granting or the denial, obviously to be fleshed out as they had their discussions. And I think that's perfectly appropriate, as Steven says, but not to be circulated among the board members in advance of the meeting, because they should not be they cannot be discussing it outside the meeting.
All right. Another question has come in. What do you recommend for adding additional support on a variance criterion in the decision? What sort of information should go in? Additional information.
I know, I'm not sure I understand the question. Janet, can you be a little more specific? I don't know, Cordell, if you understand it, feel free to answer, but I'm not.
Yeah, I'm not sure I do either.
Janet, I can unmic you turn your mic on if you would like to speak up. Just a sec here. Let's see.
Yeah, she's asking you to unmute her.
Yep. Okay. All right, you should be able to talk. No, wait, hang on. Okay. You're unmuted, so go ahead.
I don't hear her.
I did the wrong person. Hang on.
Allegedly.
Please, hang on.
Okay.
Okay, should be. Oh, all right, something's. Hang on. Let me just. Okay, it's the language is backwards. I haven't done that before. Looks like right now no. Are you able to speak now, Janet? No. All right. Allow mic. Sorry about this. All right. It says that okay, it's weird. I'm gonna have to ask somebody else how to do this, because the symbol says either there's a slash going one way, but then when I allow it, your slash just goes another way. So could you please put it in the chat until I figure out how to turn people's mics on?
Okay, in the meantime, there's another question here. If the board votes separately on the variance criteria, do those votes need to be in the decision?
Yes.
Yeah, if you're going to vote separate, yeah, I would agree that they would have to be.
Yeah, 91A2 talks about what has to be in the minutes. And it includes motions, seconds, and the vote. And so if you're doing that in the context of a variance discussion, then yes, that information needs to be in the decision.
Are we still working on unblocking Janet?
No, I think it's how the meeting is set up. So I've disabled versus enabled the mic, but either way, it's still not allowed because I didn't actually organize the meeting. So I'm pretty sure that's the answer. So Janet, if you could please put some more information into the chat.
Ooh, this is a good one. This next question.
Okay, in the morning, go ahead. I'm sorry.
Go ahead. Sorry.
Yeah, so during the morning, it was stated that the findings of facts could be written after the hearing. This person's board always makes a decision the same night of the hearing. Can the findings of fact be amended when the minutes of the hearing are accepted at the next meeting?
I think the problem with that is the notice of decision has to be issued within 5 business days, and the notice of decision has to include the findings of fact.
Right.
So, I mean, and your next meeting is almost certainly going to be a couple of weeks later, at least a week later, which is the time by which you have to have issued the notice of decision. And this is the problem with this requirement, because, as I said this morning, it's hard. It's hard to write a decision. It's easy enough to make a decision the night of the hearing. Yeah, we find these criteria are satisfied and we grant the variance. But then you have to make the findings of fact that support that, and it's hard with 5 people writing to come up with those findings of fact the same night, which is why I suggest that you assign someone to do it in consultation with your legal counsel. And I realize the problem with that is not everyone's going to agree with 100% with what goes in that written decision, but you have to do it somehow. And so I think the best you can do is you make your decision. In making your decision, you state the reasons that you're doing it, and then you talk about what's going to go in the written decision for findings of fact, and then you finalize that during the period after the hearing. I suppose you could try amending it at your next meeting. I'm just not sure that would fly. You have thoughts, Steven?
Yeah, I mean, let me talk first about amending at the next meeting. I mean, if the way I understand it, the deliberations have closed, a decision has already been rendered, and we're just talking about, what sort of written findings are going to be included in the notice of decision. And I'm concerned about a board basically reopening that application to amend the factual findings after the deliberations have been closed and a decision has been rendered. And that's completely separate from the timing issue that Cordell just brought up. I've seen recently boards handle this in one of a couple ways, but one is to include in your rules of procedure that the chair and perhaps the vice chair can work on the findings of fact as part of the notice of decision, so that you can comply with that 5 business day requirement. The other thing is, and this is challenging depending on the level of staff support that you have, but some communities, the staff are really good about creating forms where, if you're going through special exception or variance criteria, there's literally a blank piece of paper that someone is following along with to catalog all the facts that are necessary for each of those legal findings. And I think that's a really good practice, and it'll also force your board to take an official vote on the factual findings the same evening that the decision is reached, because it should all happen, simultaneous with the discussion of, are the various legal criteria satisfied for this application.
Yeah, I like that.
Okay, so the question, I'm skipping over one just for a moment because the most recent question is a follow-up to you all. So it sounds like we've heard the answer. Is the consensus then that the notice of decision must contain the board's determination separately of each of the variance criteria?
And I think it is only if that is how your board votes on variance criteria, because I think it's probably been noted that boards do this differently. Some talk about all of the criteria and have one vote on the application itself as a whole. Others go through each individual criteria and vote on those individual criteria and then vote on the application as a whole. Whatever your process is, that should be what you follow. because you have to give notice of a change in voting procedure before it goes into effect. And so, if that board, Don, if your board, if their practice is to vote separately on each of the criteria, then the notice of decision should contain each of those separate votes.
But if the board doesn't vote separately on each of the 5 criteria, they just vote, they talk about them, as you said, which, and I prefer that approach. They talk about each criterion and why various members think this one is or is not satisfied, and then they ultimately vote to grant the variance or deny the variance. I think especially if they deny the variance, wouldn't you agree that they have to say, we deny the variance because we find that it's inconsistent with the public interest, or it's inconsistent with substantial justice? They have to state at the very least, state the specific criterion that is not satisfied.
Yes, absolutely.
Okay. And ideally state why they think that criterion or those criteria are not satisfied.
Yeah, I mean, I think that the law requires the specific findings that support denial. And
Right.
so probably isn't enough to just say, we don't think that substantial justice is found. I think there's got to be some factual information, weighing the gain to the public versus the loss to the applicant.
Right.
Just using that as an example.
Right. Yeah, there was substantial testimony from abutters that this would interfere with their reasonable enjoyment of their property. It would create significant traffic problems. There was expert testimony that it would negatively affect the value of property, et cetera.
Yeah.
Those are the kinds of things that are helpful to support your decision.
Okay, thank you. So just going to back up. Is it appropriate for a board member to notify a newer zoning compliance officer of violations of a prior variance denial which was upheld in court? So just keeping the zoning compliance officer informed.
I think that's fine. Yeah, I mean, and I say that because I think ultimately it is up to the compliance officer about whether there's still a violation or not. And doesn't appear from that example that it's something that's going to come back before the ZBA for that ZBA member to give an up or down vote on.
Right.
Yep.
Okay. Yep. Oh, I'm sorry, Cordell. I might have interrupted you. Did you want to?
No, I was
add
just,
anything, or-
I was
Okay.
affirming. Yep.
Yeah. Okay. Very good. Okay, so next question. Please discuss a ZBA reconsidering its own decision within the 30-day appeal period. What should the procedure be? Must the ZBA member who asks for the rehearing be one of the ZBA members who voted in the majority? Should the ZBA address the request within that 30-day period, or does the 30 days apply only to the submission of the request to rehear the ZBA's decision?
That's a good question.
Yeah.
I unless you want to jump in, Cordell, I mean, I think that the ZBA does need to actually consider or reconsider within that 30-day period. I think the case law is very careful about saying that the board's ability to basically reverse themselves is within that 30-day period. And so that means that the ZBA is going to have to notice a new, public meeting to have that discussion within that 30-day period. As for procedure, there's nothing explicitly that talks about this, but it should be on the agenda. I think it's a best practice, and it's my suggestion that you give the applicant a heads up, or the any abutters that you know have been actively involved. Even though that it's not a public hearing, so you're not going to be taking testimony. You want to avoid an argument that they had no idea that the ZBA was potentially going to be flipping themselves. And so I always suggest that some notice be given to those parties, just so they can at least attend and observe the discussion the ZBA has.
Yeah, I agree with all of that. As far as the 30-day period, I think the case law says you can't, the board can reconsider on its own motion within 30 days. I'm not sure it says it has to be within 30 days, but I would assume that it needs to be within 30 days because, the whole point is there has to be finality. And if it's not within 30 days, then who's to say you couldn't do it, 5 years later. So, yeah, I think it has to be. And the other question is, does the ZBA member who's asking for the rehearing be one of those who voted in the majority? I don't think there's any law on that. That's sort of a Robert's Rules kind of thing that I think is too rigid. I would say, if someone voted in the minority and they come back and say, we really should reconsider this, I would say, yeah, let the board can listen to them and decide whether they want to reconsider it, even though that person didn't vote in the majority.
Yeah, I agree with that. Excuse me.
Question for you, Steven. I recently had a case where someone moved, was a abutter, the special exception was granted. The abutter moved for rehearing and filed a 10-page motion and memo saying why the rehearing should be granted. So the applicant filed a 10-page reply.
Yeah.
And the rehearing was not granted. The abutter appealed. So in the certified record, we included both of those memos.
Mm-hmm.
The abutter objected and said, because the ZBA is not supposed to consider any new evidence or any new argument in deciding whether to rehear, they shouldn't have considered the applicant's memo, and therefore it can't be part of the certified record. My reply was, well, you submitted a 10-page memo explaining why it should be reheard. I don't think it's unfair for the ZBA to consider the reply to that memo. But I don't know what the right answer to that is.
I would have given the same answer. I think you maybe don't invite the other side to provide a motion arguing against the rehearing, but it does happen. And if it comes in before the ZBA considers the request, I think it's fair game for them to take that into consideration. And obviously, it would then become part of the record that goes up to the court on appeal.
Yeah. Okay.
We have 2 new questions that came in, plus 1 follow-up question. So maybe just a quick return to the detailing reasons for denial. The question was, wouldn't those detailed reasons that have been discussed be appropriately contained in the findings of fact?
Oh, yes. I mean, if that's where they are, then that's sufficient. I think I was just saying that they need to be somewhere in that notice of decision.
Yep, agreed.
Okay. Very good. Just good to be clear. Okay, so when the ZBA is making a motion to approve or deny a variance request, we include the date of the plans which the decision is based on. Is the variance void if the planning board approves a different set of plans?
Potentially. Sorry, Cordell.
No, I was just saying, huh.
Yeah, so I think the applicant has a choice. They could either, I guess, try to challenge the planning board decision to make it more in line with the ZBA one. They can do a new, that's really all they can do probably. Or they can go back to the ZBA and ask for a revised variance that is consistent with the planning board approval. The latter of those options is probably the better one. And if it's not void, but if they go forward with a planning board approval that's inconsistent with the ZBA approval, that's an enforcement issue. And the town would say your use or whatever you're doing is inconsistent with your zoning board approval. And so we're going to do an enforcement action against you. But I would add that I did have a case where the ZBA had approved a variance and they included some language about, we're approving this based on the plan that is presented before us. And then the plan did change. And it was kind of a convoluted case, but the court said that when that happens, it is really an enforcement issue at that point, and that the ZBA should not sort of reinsert itself and claim that the original decision is void because of the change in plans. That really should be reserved for the enforcement arm of the town government.
Yeah, right. Yeah, that makes sense. ZBA doesn't have the authority to go out and say, come back and reapply.
Right.
Right. Okay.
All right. Okay. Here's another one. From the time an application is received by our land use support person, what is the time frame that a hearing must be scheduled and a decision rendered based on the time the application is received by the land use support person?
Once it's, unless I'm missing something, the application's received, you have to hold a hearing within 45 days and make a decision within 90 days. Yeah. Again, subject to what I said this morning about being able to continue that, get a waiver from the applicant, or deny it without prejudice if they're not willing to provide the information that you need. But the basic rule is 45 days to hold the hearing and 90 days to make a decision. I haven't missed anything on that, have I, Steven?
No, I agree.
Yeah. Okay. So we do have time for maybe a couple more questions if anybody has them. The microphone thing doesn't work, so if you still have a question, please go ahead and put it in the chat. We can wait around for another minute or two and see if anybody has more questions.
And just while people are maybe typing, I just wanted to give a heads up that the email address that you're looking at for me is missing an H after the
Whitley. Yep. Okay.
So if you're trying to send me, something, make sure you add that H.
Excellent. Thank you. We'll change that slide.
I guess you never were successful in unmuting Janet.
No.
I'll try and answer to that question. The question was, what do you recommend for adding additional support on a variance criterion in the decision? I would say, let's say, and I used this example this morning. One of the issues is, would it negatively affect the value of neighboring properties? And if you're going to deny it based on that, you can say in your decision, we heard testimony from abutters that they felt that it would reduce the value of their property. Ideally, better than that, we heard testimony from an experienced appraiser that it would have this, 10% reduction on the value of properties or something like that. Whatever testimony you heard or evidence you received that goes to one of those 5 criteria, I would cite that in your findings of fact for why you are or are not granting the variance or the special exception or whatever it is that you're doing.
Okay. Let's see. Haven't gone through all our slides. I wonder if any of them are important. Okay, they're the session controls. I should have shown people that, but I think you're all able to figure that out. We do still have 5 minutes, so again, any other questions? Otherwise, I'm going to place something in the chat. This is the form, once again, the evaluation form. So please, if you, we do like to find out what worked and what didn't and how we can do better as, as we continue doing our conferences in the coming years. Any other final words, Steven or Cordell?
No, just thank you to Cordell and to BEA and OPD for doing this and for having me.
Thank you all, and be careful out there.
Yeah. Okay. Once again, thank you all for attending. And the slides will be available for viewing and download on the conference webpage. And we'll have the link to all of these recordings on our YouTube channel by early next week. So once again, fill out that evaluation form if you get a chance. We will appreciate that. And with that, we are done, and enjoy the rest of your weekend.
Great.
Thank you.
Okay.